Hello, I'll give you some reasons why listening to audio reviewers promotes health. One is because you can still walk around while listening to reviewers. Study shows that a 7-minute walk around the house or outside the office or even just up and down the stairs will greatly impact your health. Two, you can sit up, you can do some sit ups, or you can do some jumping too. So, what are you waiting for? Go ahead and hit that subscribe button. Let's study and stay healthy. Thanks. The fundamental powers in the Bill of Rights. Governance is the art and science of carefully balancing competing needs, concerns, wants, desiderata, and values of society, all demanding acceptance and preeminence. Insofar as the government and the people are concerned, their interests may every now and then clash or compete for ascendancy, for which a careful weighing of various considerations has to be done to ensure that the demands of authority do not lead to slavery and the claims of liberty do not end up in anarchy. More recently, the court also framed it in this wise: how does the charter of a republican and democratic state achieve a viable and acceptable balance between liberty, without which government becomes an unbearable tyrant, and authority, without which society becomes an intolerable and dangerous arrangement? And for the present, such balancing may assume greater importance as the government tries to come up with a society free of drug related crimes while still respecting basic human rights. On the side of authority, you have the inherent and fundamental powers of the government: police power, eminent domain, and taxation, powers by which its goals may be achieved and its will enforced and implemented. On the other hand, you have the guarantees and safeguards found in the Bill of Rights, and in this regard, the court has held that in the complex but exquisite scheme laid down by the Constitution, the Bill of Rights occupies a position of primacy, way above the articles on governmental power. In this interplay between power and authority on one hand, and liberty and freedom on the other, note must be taken of the fact that just like anything else, values, concepts, and ideas change through time. What may have been recognized as outside the domain of state regulation in the past would no longer be so immune from governmental interference in later years. As was said in one case, what was robbery in 1874 is now called social justice. Or as stated in elsewhere, social justice is not based on rigid formulas set in stone. It has to allow for changing times and circumstances. The fundamental powers. These fundamental powers are inherent in the national government, exercised by the legislature, and are only bestowed upon others, like the local government unit, as a result of delegation. In the exercise of police power, there must be compliance with the requirements of legitimate ends being accomplished through legitimate means. This power is the most pervasive, illimitable, and plenary, affecting liberty and property of individuals for the advancement of the common good. It essentially embodies the right of the state to enact laws for the purpose of promoting the public welfare by restraining and regulating liberty and the use of property. It's also been said that the test of constitutionality of a police power is limited to an inquiry on whether the restriction imposed on constitutional rights is reasonable, and not whether it imposes a restriction on those rights, in that it does not rely upon the existence of definitive studies to support its use. Indeed, no requirement exists that the exercise of police power must first be conclusively justified by research, scientific certainty, and conclusiveness, though desirable, may not be demanded in every situation. Otherwise, no government will be able to act in situations demanding the exercise of its residual powers because it will be tied up conducting studies. Pursuant to police power, security of tenure may be reasonably regulated to safeguard health, morals, peace, education, order, safety, and the general welfare of the people. Persons who decide to engage in the learned professions requiring scientific or technical knowledge may be required to take an examination as a prerequisite to engaging in their chosen careers. And where particular arrangements such as the so-called referral decking system, RDS, is found not to guarantee the migrant workers' right to safe and quality health services, then it may be validly ordered to be discontinued. With regard to the promotion of the welfare of senior citizens and persons with disabilities, the grant of 20% discount in their purchase of medicine has been upheld in Carlos Superdrug Corporation versus Department of Social Welfare and Development, or DSWD, 526 SCRA 130, Southern Luzon Drugs Corporation versus Department of Social Welfare and Development, 824 SCRA 164, and Drugstore Associations of the Philippines versus National Council on Disability Affairs, among others. Insofar as the temporary 6-month closure in 2018 of Boracay Island as a tourist destination is concerned, the court held in Zabal versus Duterte, SCRA or GR 238467, February 12, 2019, that it was a valid police power measure to rehabilitate the island and prevent further degradation. Indeed, the temporary closure of Boracay, although unprecedented and radical as it may seem, was reasonably necessary and not unduly oppressive under the circumstances. It was the most practical and realistic means of ensuring that rehabilitation works in the island are started and carried out in the most efficacious and expeditious way. And insofar as the exercise of delegated police power is concerned, the same should be in accordance with national government policies. As for the power of condemnation, the Constitution already provides the allowable standards for its exercise, public use, and just compensation. But then, note must be taken of the expanded meaning of the term public use. The concept of public use is not limited to traditional purposes. Here, as elsewhere, the idea that public use is strictly limited to clear cases of use by the public has been discarded, and case law has recently come up with the newer rules relative to the exercise of this power. The exercise of eminent domain demands the payment of just compensation. Regulation may also have the effect of taking, but the same is not compensable, as it is part of police power. Nevertheless, when the deprivation or reduction of profits or income or gross sales is shown to be unreasonable, oppressive, or confiscatory, then the challenged governmental regulation may be nullified for being a taking under the power of eminent domain. In such a case, it is not profits or income or gross sales which are actually taken and appropriated for public use. Rather, when the regulation causes an establishment to incur losses in an unreasonable, oppressive, or confiscatory manner, what is actually taken is capital and the right of the business establishment to a reasonable return on investment. If the business losses are not halted because of the continued operation of the regulation, this eventually leads to the destruction of the business and the total loss of the capital invested therein. Taxation, of course, must not be exercised in an unreasonable, oppressive, and confiscatory manner. Or, in the language of Philippine health care providers versus Commissioner of Internal Revenue, a legitimate enterprise has enjoyed the constitutional protection not to be taxed out of existence. In another case, in Commissioner of Internal Revenue versus United Salvage and Towages, the court held that it cannot countenance an assessment based on estimates that appear to have been arbitrarily or capriciously arrived at. Arbitrariness will negate the very reason for government itself. And in Pelisloy Realty Corporation versus Province of Benguet, 695 SCRA, 491, in 2013, it said that it will not tolerate an arbitrary interpretation or application of tax law, inflicting an injustice on unassuming taxpayers. Also, It must not be forgotten that the exercise of the power of taxation constitutes a deprivation of property under the Due Process Clause, and the taxpayer's right to due process is violated when arbitrary or oppressive methods are used in assessing and collecting taxes. Further, in regard to the delegation by the Constitution itself of the taxing power to the local government units, Congress is not stripped of its power to exempt certain entities from local taxation. And on residual powers of local government units, the court has held that a local government unit may exercise its residual power to tax when there is neither a grant nor a prohibition by statute, or when such taxes, fees, or charges are not otherwise specifically enumerated in the local government code, National Internal Revenue Code, as amended, or other applicable laws. In the present case, Section 140 in relation to Section 131, letter C of the Local Government Code already explicitly and clearly cover amusement tax, and respondent Cebu City must exercise its authority to impose amusement tax within the limitation and guidelines as set forth in said statutory provisions. Finally, the authority of the Bureau of Internal Revenue to overrule, correct, or reverse the mistakes or errors of its agents is conceded. However, this authority must be exercised reasonably. That is, only when the action or ruling is patently erroneous or patently contrary to law. Bill of Rights. Taking up the cudgels for liberty or the guarantees contained basically in the Bill of Rights, as the court observed in People v. Legaspi 331 Scrot 95. The Bill of Rights is the mechanism for the delicate balance between governmental power and individual liberty, without which man is stripped of his humanity and society becomes a putrid dump of lost lives. The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, of free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. The bundle of freedoms and liberties guaranteed by the Bill of Rights is essentially directed against the state and its agencies and instrumentalities only. It could not be invoked against private persons. In Sesbrenio v. Court of Appeal 720 Scra 57, the presence of a policeman in an inspection of the electric meter of a residence for possible meter tampering was not considered as a situation subject to the provision of the Bill of Rights on searches and seizures. The participation of the policeman, not an employee of the private electrical company, was to render police assistance to ensure the personal security of private entities' employees during the inspection, rendering him a necessary part of the team as an authorized representative. Nevertheless, even as it is true that the Constitution cannot control private prejudices, but neither can it tolerate them. Private biases may be outside the reach of the law, but the law cannot directly or indirectly give them effect. Due process. Due process might as well provide a sort of Swiss Army knife guarantee, given its adaptability and flexibility as a legal argument. The Due Process Clause is a handy legal tool for the protection of the valued rights to life, liberty, and property, and all other freedoms and liberties that inhere or adhere to them. It provides both a safeguard to ensure fairness in the proceedings that may be taken towards deprivation of any liberty or property interests, or the impairment of any other rights or freedom, as well as the guarantee of reasonableness in the enactment of laws and other regulations which impact life, liberty, and property. Person includes both citizens and aliens, natural and juridical. It may not encompass, however, the fetus or the unborn child, though the 1987 Constitution has thought it advisable to provide protection for the unborn together with its mother. The clear and unequivocal intent of the framers of the 1987 Constitution in protecting the life of the unborn from conception was to prevent the legislature from enacting a measure legalizing abortion. It was so clear that even the court cannot interpret it otherwise. This intent of the framers was captured in the record of the proceedings of the 1986 Constitutional Commission. Even a dead person is entitled to some form of protection insofar as his or her estate is concerned. As for life, liberty, and property, while all of these are protected, the extent of the care and importance they get are not the same. Some things are simply worth much more than others. Thus, when property rights come into conflict with human rights, the former must give way to the latter. When freedom of the mind is imperiled by law, it is freedom that commands a momentum of respect. When property is imperiled, it is the lawmaker's judgment that commands respect. This dual standard may not precisely reverse the presumption of constitutionality in civil liberties cases, but obviously it does set up a hierarchy of values within the due process clause. And the court also stated that, based on the hierarchy of constitutionally protected rights, the right to life enjoys precedence over the right to property. The reason is obvious: life is irreplaceable, property is not. When the state or LGU's exercise of police power clashes with a few individuals' right to property, the former should prevail. As between right not to join labor organization, the court had this to say. In the hierarchy of constitutional values, this court has repeatedly held that the right to abstain from joining a labor organization is subordinate to the policy of encouraging unionism as an instrument of social justice. Also, the law recognizes that the enjoyment of a private reputation is as much a constitutional right as the possession of life, liberty, or property. And if there is a hierarchy of rights, there is also a hierarchy of evidentiary values, which calls into play the guarantee of the due process clause if the inappropriate quantum of proof is demanded by the adjudicator in a particular proceeding. Relevant to the chore of weighing conflicting values are so-called standards of review or levels of scrutiny, or those instruments of measurement for validity of rules and regulations, adjustable and flexible depending on the interests and values involved. These would be the differential or rational relationship test, the intermediate or heightened scrutiny, and finally, strict scrutiny. Determining whether there is sufficient justification for the government's action depends very much on the level of scrutiny used. This simply means that if the liberty involved were freedom of the mind or the person, the standard for the validity of governmental acts is much more rigorous and exacting. But where the liberty curtailed affects what are, at the most, rights of property, the permissible scope of regulatory measure is wider. Thus, under differential review, laws are upheld if they rationally further a legitimate governmental interest, without courts seriously inquiring into the substantiality of such interest and examining the alternative means by which the objectives could be achieved. Under intermediate review and substantiality of the governmental interest is seriously looked into, and the availability of less restrictive alternatives are considered. Under strict scrutiny, the focus is on the presence of compelling rather than substantial governmental interest and on the absence of less restrictive means for achieving that interest. Strict scrutiny is a judicial standard for determining the quality and the amount of governmental interest brought to justify the regulation of fundamental freedoms. It is used today to test the validity of laws dealing with the regulation of speech, gender, or race, and facial challenges are allowed for this purpose. The court has also declared constitutional due process demands a higher degree of clarity when infringements on life or liberty are intended. In the matter of statutes that deprive a person of physical liberty, the demand for a clearer standard in sentencing is even more exacting. If one were to have a better appreciation of these standards of review, why not try to reminisce about the law school years where classroom sessions were either a bore, moments of trepidation, and incessant prayers, or occasions for hilarious incidents, courtesy of members other than the ones enjoying the fun? A student's preparations for each subject then were generally dictated by the kind of professors he or she might have had, whether members of terrorist cells or the soft and kind apostles of nonviolence and charity. As for property, aside from those normally owned, it must also be understood that a final judgment vests in the prevailing party a right recognized and protected by law under the Due Process Clause of the Constitution. It is a vested interest which the government should recognize and protect, and of which the individual could not be deprived arbitrarily of without committing an act of injustice. Likewise, where an employee retires and meets the eligibility requirements under the law, he acquires a vested right to benefits that is protected by the Due Process Clause. And while one may not be deprived of what is his vested right, the same may be lost if such deprivation is founded on law and jurisprudence, such as in legal separation, where the guilty spouse may end forfeiting his share in the conjugal property. Public office is not property, and one cannot insist on staying in office if the office has already been abolished. But to the extent that one's right to security of tenure may be impaired, to that extent may due process be called upon for assistance. Unduly long preventive suspension could also be assailed on due process grounds. Licenses, while merely in the nature of a privilege, are not also insulated from the checking effects of the Due Process Clause, especially if abuse attended their withdrawal or discontinuance. The mere fact that one's claim to something might be based on a privilege and not a right is not determinative of the appropriateness of invoking due process. Reliance on the right privilege dichotomy has long been denigrated by leading light in an administrative law as too crude for consistent application by courts. Under traditional form of property ownership, recipients of privileges or largeness from the government could be said to have no property rights because they possess no traditionally recognized proprietary interest therein. But the right privilege dichotomy came to an end when courts realized that individuals should not be subjected to the unfettered whims of government officials to withhold privileges previously given to them. Indeed, to perpetuate such distinction would leave the citizens at the mercy of state functionaries, and worse, threaten the liberties protected by the Bill of Rights. Sight must not be lost of the fact that the clause has two phases or components, the procedural and the substantive. The former is essentially directed at officers who adjudicate, while the latter is directed basically at those who enact the laws. The first refers to the guarantees of fairness in the process of determining whether a right, liberty, or freedom is to be impaired or otherwise taken away, while the latter goes to the very power of the authorities to come up with rules and other strictures under which man may live and enjoy the blessings of a civilized society, including the price that he has to pay to stay. Then again, it must not also be forgotten that procedural due process operates differently under changing circumstances. Classic procedural due process issues are concerned with what kind of notice and what form of hearing the government must provide when it takes a particular action. Or, as stated in another case, procedural due process requires a determination of what process is due, when it is due, and the degree of what is due. What may be required for purposes of judicial proceedings would not be the same in administrative proceedings. Those that satisfy the requirements of due process in the investigation of local appointive officials would not suffice for elective officials, and so on. It has also been held that where the trial court simply considered the person and past performance of the witness and decided on this basis that he was a creditable witness rather than look at the merits of his testimony, such act by itself was a major error, a violation of due process. A court must always decide on the basis of the evidence presented, not on the basis of any other extraneous consideration not before it. Basic to the idea of procedural due process is the presence of an impartial magistrate or tribunal, if fairness is to be had. In Office of the Court Administrator versus Flora Jr., it was held that where a judge entertains an orthodox belief system, such as believing in psychic visions and in dwarves and in being able to write while on trance, of having been seen by several people in two places at the same time, and of foreseeing the future because of his power of psychic phenomenon, the same indubitably shows his inability to function with the cold neutrality of an impartial judge. Such beliefs, especially so when acted upon by the judge, are so at odds with the critical and impartial thinking required of a magistrate. The judiciary is certainly not the proper place for such a person to stay. And in Rubin versus Corpus Cabochan, the court pointed out it must be borne in mind that the inhibition of judges is rooted in the Constitution, specifically Article 3, the Bill of Rights, which requires that a hearing is conducted before an impartial and disinterested tribunal, because unquestionably, every litigant is entitled to nothing less than the cold neutrality of an impartial judge. All of the other elements of due process, like notice and hearing, would be meaningless if the ultimate decision would come from a partial and biased judge. On substantive due process, relevant here is the concept of the void for vagueness doctrine. It is most commonly stated to the effect that a statute establishing a criminal offense must define the offense with sufficient definiteness that persons of ordinary intelligence can understand what conduct is prohibited by the statute. It can only be invoked against that species of legislation that is utterly vague on its face, that is, that which cannot be clarified either by a saving clause or by construction. A statute or act may be said to be vague when it lacks comprehensive standards that men of common intelligence must necessarily guess at its meaning and differ in its application. In such instance, the statute is repugnant to the Constitution in two respects. It violates due process for failure to accord persons, especially the parties targeted by it, fair notice of what conduct to avoid, and it leaves law enforcers unbridled discretion in carrying out its provisions and becomes an arbitrary flexing of the government muscle. And what about the Obergefell doctrine? This doctrine decrees that a governmental purpose may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. If one's purpose is simply to roast a pig, then he needed not have to burn the barn. Due process guarantees have far-reaching consequences and ramifications. In the United States, for instance, it has been implicated in the right of a woman to have an abortion, and likewise, it has been attempted unsuccessfully to justify a claim to right to suicide. And it has also been invoked to justify the compelled production of relevant presidential materials as against a generalized assertion of executive privilege. So this due process makes its presence known in the requirement for reasonableness of presumptions, as well as in relation to the right not to be subjected to excessive exemplary damages. In regard to criminal cases, due process is implicated in the determination of voluntariness and admissibility of extrajudicial confessions. The requirement for public trial and the reasonable doubt standard are deemed dictates of due process. Court access by prisoners is also considered part of the guarantee. The constitutional guarantee of due process of law has a corollary, the requirement that prisoners be afforded access to the courts in order to challenge unlawful convictions and to seek redress for violations of their constitutional rights. This means that inmates must have a reasonable opportunity to seek and receive the assistance of attorneys. In the Philippines, the court has ruled, for instance, that inordinate reliance on technical rules of procedure may also offer the guarantee. Exorbitant and unreasonable filing fees likewise violate due process. A filing fee, by legal definition, is a charge by a public official to accept a document for processing. The fee should be just, fair, and proportionate to the service of which the fee is being collected. The due process clause permits the court to determine whether the regulation imposing such fee is reasonable and within the bounds of its rate fixing authority, and to strike it down when it arbitrarily infringes upon a person's right to property. Due process has also been referred to in relation to the rights to counsel, information, equal protection, need for courts to explicitly state the factual and legal basis for their judgments. It has likewise been considered in connection with expropriations. In Republic versus Kagandahan, the court recognized the right of a person with the condition of congenital adrenal hyperplasia, CAH, or intersexuality to have her birth certificate corrected to indicate the gender that such persons may think he or she has, which is different from what was indicated at the moment of birth. It is a recognition of such person's liberty to choose what he or she really is. It was noted that the current state of Philippine statutes apparently compels that a person be classified either as a male or as a female, but the court is not controlled by mere appearances when nature itself fundamentally negates such rigid classification. Ultimately, we are of the view that where the person is biologically or naturally intersex, the determining factor is his gender classification would be what the individual, like respondent, having reached the age of maturity with good reason to think of his her sex. Respondent here thinks of himself as a male, and considering that his body produces high levels of male hormones, androgen, there is preponderant biological support for considering him as being male. Sexual development in cases of intersex persons makes the gender classification at birth inconclusive. It is at maturity that the gender of such persons, like respondent, is fixed. Nevertheless, caution should also be had in using it indiscriminately, for it could as soon lend itself to noticeable misuse. Depending on how well one may wield the due process argument, he may find an ally or just an illusory companion. In one case, the Supreme Court opened its opinion with this observation: it has not escaped the attention of the court that when a party runs out of arguments, or never had any to begin with, it usually pleads a denial of due process. The plea may impress at first glance what with all its plaintive invocation of the Bill of Rights, but it does not often succeed upon closer examination. In another case, it concluded with this observation: the court is not unaware of the practice of some lawyers who, lacking plausible support for their position, simply claim a denial of due process as if it were a universal absolution. The ground will prove unavailing, and not surprisingly, since it is virtually only a pro forma argument. Due process is not to be bandied like a slogan. It is not a mere catchphrase. As the highest hallmark of the free society, its name should not be invoked in vain, but only when justice has not been truly served. The court also observed in another case: the court shall not fake naivete to the prevalent practice among lawyers who, for lack of better argument to bolster their position, engage in waxing lyrical to a denial of due process. Finally, the court has come up with the concept of statutory due process in order to distinguish it from constitutional due process. In Serrano versus National Labor Relations Commission, the court held that the dismissal of an employee who was separated for cause without affording him the notice required by law was considered ineffectual until validated by final judgment. In effect, the employee would be deemed still an employee in the meantime and accordingly entitled to his wages until his dismissal would have been affirmed. The court majority in that case was also emphatic that such dismissal was not a violation of due process, as the guarantee in the Bill of Rights is directed against governmental action, not private acts. Then, in Agabon versus National Labor Relations Commission, the court characterized the dismissal without complying with the notice requirement as a violation of due process. How did it turn around in a manner that it is not entirely contrary to what it said 4 years earlier? Simply, it came up with something new, two concepts of due process: A, constitutional due process, and B, statutory due process. While under the former, its violation would lead to the nullity of the action made. In the latter, it would not necessarily be the case, depending on what the statute violated itself provides. Sonar versus Ermita. In our jurisdiction, the constitutional guarantee of due process is also not limited to an exact definition. It is flexible in that it depends on the circumstances and varies with the subject matter and the necessities of the situation. Nevertheless, the idea that a formal hearing is not indispensable should not be hastily thrown around by administrative bodies. Thus, it would be more in keeping with administrative due process that the conduct of a hearing be the general rule rather than the exception. In Cambe versus Office of the Ombudsman, Cambe reiterates the rule enunciated in Estrada versus Office of the Ombudsman that there is no law or rule which requires the Ombudsman to furnish a respondent with copies of the counter affidavits of his correspondents. It is not part of the guarantee of due process. In Republic versus Albios, if a marriage of convenience, that is, for the acquisition of foreign citizenship, does not work out as planned, could that be a ground for declaration of nullity? No. The court ruled in this case motives for entering into a marriage are varied and complex. The state does not and cannot dictate on the kind of life that a couple chooses to lead. Any attempt to regulate their lifestyle would go into the realm of their right to privacy and would raise serious constitutional questions. The right to marital privacy allows married couples to structure their marriages in almost any way they see fit, to live together or live apart, to have children or no children, to love one another or not, and so on. Thus, marriage is entered into for other purposes, limited or otherwise, such as convenience, companionship, money, status, and title, provided they comply with all the legal requisites, are equally valid. Thus, although the marriage may be considered a sham or fraudulent for the purpose of immigration, it is not void ab initio and continues to be valid and subsisting. In the case of Obergefell versus Hodges, marriage is traditionally understood as a union between man and woman. Two persons of the same sex have the right to demand that their similar arrangement be recognized and legitimized by the government. In this case, the U.S. Supreme Court said yes. It is part of the protected liberty and trust of individuals, a means by which they define and express their identity. The court also noted that the institution of marriage has evolved over time. The court further held that the identification and protection of fundamental rights is an enduring part of the judicial duty to interpret the Constitution. That responsibility, however, has not been reduced to any formula. Rather, it requires courts to exercise reasoned judgment in identifying interests of the person so fundamental that the state must accord them its respect. And to highlight the flexibility of ideas and legal principles, the court said it cannot be denied that this court's cases describing the right to marry presumed a relationship involving opposite sex partners. The court, like many institutions, has made assumptions defined by the world and time of which it is a part. The court further held that the court must respect the basic reasons why the right to marry has been long protected. This analysis compels the conclusion that same sex couples may exercise the right to marry. The four principles and traditions to be discussed demonstrates that the reasons marriage is fundamental under the Constitution apply with equal force to same sex couples. It went to hold that a first premise of the court's relevant precedents is that The right to personal choice regarding marriage is inherent in the concept of individual autonomy. Further, a second principle in this court's jurisprudence is that the right to marry is fundamental because it supports a two-person union unlike any other in its importance to the committed individuals. And third basis for the protection of the right to marry is that it safeguards children and families and thus draws meaning from related rights to child rearing, procreation, and education. Ultimately, fourth and finally, this court's cases and the nation's traditions make clear that marriage is a keystone of our social order. Accordingly, the limitation of marriage to opposite sex couples may long have seemed natural and just, but its inconsistency with the central meaning of the fundamental right to marry is now manifest. With that knowledge must come the recognition that laws excluding same sex couples from the marriage right impose stigma and injury of the kind prohibited by our basic charter. The court further declared the right to marry is fundamental as a matter of history and tradition, but rights come not from ancient sources alone. They rise too from a better informed understanding of how constitutional imperatives define a liberty that remains urgent in our own era. Many who deem same sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises, and neither they nor their beliefs are disparaged here. But when that sincere personal opposition becomes enacted law and public policy, the necessary consequence is to put the imprimatur of the state itself or an exclusion that soon demeans or stigmatizes those whose own liberty is then denied. Under the Constitution, same sex couples seek in marriage the same legal treatment as opposite sex couples, and it would disparage their choices and diminish their personhood to deny them this right. The right of same sex couples to marry that is part of the liberty promised by the 14th Amendment is derived, too, from the amendment's guarantee of the equal protection of the laws. The Due Process Clause and the Equal Protection Clause are connected in a profound way, though they set forth independent principles. Rights implicit in liberty and rights secured by equal protection may rest on different precepts and are not always coextensive. Yet, in some instances, each may be instructive as to the meaning and reach of the other. In any particular case, one clause may be thought to capture the essence of the right in a more accurate and comprehensive way, even as the two clauses may converge in the identification and definition of the right. The long and short of it, the right to marry is a fundamental right inherent in the liberty of the person, and under the Due Process and Equal Protection Clause of the 14th Amendment, couples of the same sex may not be deprived of that right and that liberty. The court now holds that same sex couples may exercise the fundamental right to marry. In case of Cudia versus Superintendent of the Philippine Military Academy, in regard to administrative investigations involving students in military schools, the court held, like in other institutions of higher learning, there is aversion towards undue judicialization of an administrative hearing in the military academy. It has been said that the mission of the military is unique in the sense that its primary business is to fight or be ready to fight wars should the occasion arise, and that over proceduralizing military determinations necessarily gives soldiers less time to accomplish this task. Extensive cadet investigations and complex due process hearing could sacrifice simplicity, practicality, and timeliness. Excessive delays cannot be tolerated since it is unfair to the accused, to his or her fellow cadets, to the academy, and generally to the armed forces. A good balance should, therefore, be struck to achieve fairness, thoroughness, and efficiency. Equal protection. The guarantee of equal protection is no argument for absolute equality. for it only assures is legal equality. It would hardly be fair nor just that people who are not equally circumstanced be given the same treatment. Otherwise, it would be as offensive to the notion as the very idea of an equal treatment among equals. Inherent, therefore, in the application of the Equal Protection Clause is the need for valid classifications so as to determine who or what could properly be grouped together for particular treatment and excluding all others. As the court intoned in Marital versus Department of Public Works and Highways, to begin with, classification by itself is not prohibited, and then went on to state that not all motorized vehicles are created equal. In this regard, the classification must be related to the very purpose of the law, and that there should be substantial distinctions which make for real differences. Gender may be relevant in regard to certain classifications, but not in others. Age, legitimacy, academic performance, course of study, office and status, and other bases for classification may make for some valid differences at times, but not so under other situations, and so on. And what may be constitutional when seen from one perspective may not be so from another perspective. In Republic versus Manolo, paragraph 2, Article 26 of the Family Code has been understood to mean that it should be the foreign spouse of a Filipino who should secure a divorce in order to free the Filipino from the marriage bond. In Manolo, the court said that to construe such provision in that manner would run afoul of the Equal Protection Clause. The limitation of the provision only to a foreign divorce initiated by the alien spouse is unreasonable, as it is based on superficial, arbitrary, and whimsical classification. There is no real and substantial difference between a Filipino who initiated a foreign divorce proceeding and a Filipino who obtained a divorce decree upon the instance of his or her alien spouse. In the eyes of the Philippine and foreign laws, both are considered as Filipinos who have the same rights and obligations in an alien land. Hence, to make a distinction between them based merely on the superficial difference of whether they initiated the divorce proceedings or not is utterly unfair. The treatment gives undue favor to one and unjustly discriminate against the other. In the case of Mosqueda versus Filipino Banana Growers and Export Association, in regard to the ban imposed by the city of Davao on aerial spraying as an agricultural practice, which the court held to be invalid for being unreasonable as well as being violative of the Equal Protection Clause, the court also discussed some significant concepts such as levels of scrutiny and over-inclusiveness and under-inclusiveness. The reasonability of a distinction and sufficiency of the justification given by the government for its conduct is gauged by using a means end test. This test requires analysis of 1. The interest of the public that generally requires exercise, as distinguished from those of a particular class, and 2. The means employed and are reasonably necessary for the accomplishment of the purpose and are not unduly oppressive upon individuals. To determine the propriety of the classification, courts resort to 3 levels of scrutiny, that is, the rational scrutiny, intermediate scrutiny, and strict course scrutiny. Of study, office and status, and other bases known as for the classification may make for some valid differences at times, demands that so the classification reasonably relate to the legislative purpose. And the rational what may be constitutional when seen from one perspective may not be so or social from another perspective, or to any other case not involving a suspect class. When the classification puts a quasi-suspect class at a disadvantage, it will be treated under intermediate or heightened review. Classifications based on gender or illegitimacy receives intermediate scrutiny. To survive intermediate scrutiny, the law must not only further an important governmental interest and be substantially related to the interest, but the justification for the classification must be genuine and must not depend on broad generalizations. The strict scrutiny review applies when the legislative classification impermissibly interferes with the exercise of a fundamental right or operates to the peculiar class disadvantage of a suspect class. The government carries the burden to prove that the classification is necessary to achieve a compelling state interest, and that is the least restrictive means to protect such interest. As to whether a measure is too narrow or too broad, the court had this to say. The occurrence of pesticide drift is not limited to aerial spraying but results from the conduct of any mode of pesticide application. Even manual spraying or truck mounted boom spraying produces drift that may bring about the same inconvenience, discomfort, and alleged health risk to the community and to the environment. A ban against aerial spraying does not weed out the harm that the ordinance seeks to achieve. In the process, the ordinance suffers from being under inclusive because the classification does not include all individuals tainted with the same mischief that the law seeks to eliminate. A classification that is drastically under inclusive with respect to the purpose or end appears as an irrational means to legislative end because it poorly serves the intended purpose of the law. Further, aside from it being under inclusive, the assailed ordinance also tend to be over inclusive because its impending implementation will affect groups that have no relation to the accomplishment of the legislative purpose. Its implementation will unnecessarily impose a burden on a wider range of individuals than those included in the intended class based on the purpose of the law. It can be noted that the imposition of the ban is too broad because the ordinance applies irrespective of the substance to be aerially applied and irrespective of the agricultural activity to be conducted. The imposition of the ban against aerial spraying of substances other than fungicides and regardless of the agricultural activity being performed becomes unreasonable inasmuch as it patently bears no relation to the purported inconvenience, discomfort, health risk, and environmental danger which the ordinance seeks to address.